I'm Nisha Mohamed, a practicing barrister in Hong Kong at Gilt Chambers and the co-author of Colinvaux Law of Insurance Hong Kong with Professor Robert Merkin and Ozlem Gurses. Today what I'll be doing is I'll be covering the latest developments in the area of insurance and also some of the Hong Kong cases. The new edition of Colinvaux has its origins in a work published in 2003, and there has been a lot of recent developments which necessitated the need for a new edition. There is a completely new editorial team under the skillful leadership of Professor Robert Merkin. The new edition also takes into account the recent changes in the law of the PRC as early as October 2009. Insurance law has never been more important, especially due to the increase of claims due to the financial crisis and the liability of directors and other officials in relation to derivative actions and other claims. There have been landmark decisions, especially from the English courts, and the recent decision of Wasser and Lexington, where the court held that the reinsurer was entitled to rely upon the law applicable to the reinsurance agreement and is not bound to accept the judgment against the reinsured if it's based on a foreign law, unless it was clear at the outset which law applied to the direct policy. In that case, also the courts covered back-to-back, the phrase back-to-back, and it says that the trend for this sort of cover seems to have been halted. Another important decision is Kitson and Lloyd's Underwriters, which for the first time laid down the rules on operation of claims-made liability insurance with respect to what must be notified, when it must be notified, and how it must be notified. The book covers a range of topics as well as Hong Kong cases and takes into account the recent developments in insurance law. The law of utmost good faith has been transformed, with the emphasis being placed on the inducement of the insurer who has underwritten the risk, rather than the objective prudent insurer. The court has also removed the risk of the insurer being found, by reason of waiver, to have lost their rights to rely upon the breaches of the condition precedent, and the case for that is Cosma Villas. The law of utmost good faith has been transformed, with the emphasis being placed on the inducement of the insurer who has underwritten the risk, rather than the objective prudent insurer. The court has also removed the risk of the insurer being found, by reason of waiver, to have lost their rights to rely upon the condition precedent, and the case for that is Cosmas and Villas. Cases since the last edition have confirmed that for disclosure purposes, the key issue these days is inducement and not materiality, Lewis and Norwich, and the Hong Kong case on this point is Nam Quang Medicines. For claims as to what constitutes reasonable time was reiterated in the decision of Lexington Insurance Co., and there was another case, Porter and Zurich, which deals with the duties of the assured. And for the first time, the criminal principles of insanity were brought into a case on claims. For claims as to what constitutes reasonable time was reiterated in the case of Lexington Insurance Company. And there was another case of Porter and Zurich, which deals with the duties of the assured. And in that case, for the first time, criminal principles of insanity were brought into a case on claims. For liability insurance, there is a requirement for compulsory insurance in Hong Kong. For example, you have the employer's liability under the Employees' Compensation Ordinance. A recent case on the scope of coverage for forms of liability insurance is employer's liability trigger litigation. In that case, it deals with the public liability policy. However, that case has to be contrasted with the previous decisions of Bolton Metropolitan Borough Council and also the decision of Commercial Union Assurance. There are also conflicting cases dealing with coverage based on the assured's activities, and the decision of NCO remediation is consistent with the Australian and Canadian authorities, which held that liability for the supply of services does not include liability for the defects in the products which are supplied with those services. However, this decision has to be contrasted with the previous decision of Bedfordshire Police Authority. For property insurance in Ansari and New India Assurance Limited, the court stated that the test for materiality was not the wide one as laid down for pre-contract disclosure, but a much narrower one. And for marine insurance in Hong Kong has adopted verbatim the English Marine Insurance Act 1906 in its own marine insurance ordinance. And there is the recent UK decision of Global Process Systems Incorporated, which deals with the uninsurability of inevitable loss and the notice of abandonment. And it's likely that if a similar situation arose in Hong Kong, the courts in Hong Kong would follow the same principles. The development in the area of warranties has suggested that warranties is slowly being modified to make it clear that the insurers cannot force the assured to warrant behavior which it is impossible for him to comply with. For example, you've got the crewing warranty in the case of Pratt and Avigon. There is also a chapter dealing with the regulatory framework applicable to insurers and intermediaries in Hong Kong, which is currently governed by the Insurance Companies Ordinance. There is also a chapter which deals with the PRC law, and in the PRC, the law is codified in their Insurance Act, which has recently been through its second revision by the MPC and will come into effect on 10th October 2009. This book is for practitioners and all those interested in insurance law.